All right, welcome back, everyone. Our second panel today is entitled Better Religious Freedom Law from a Better Grasp of Religion. I'm going to give very brief introductions to our speakers, all of whose illustrious biographies are available to you in the program materials, so that we can maximize the amount of actual substantive discussion we have. So our first paper is going to be presented by Dr. Francis J. Beckwith, who is professor of philosophy and church-state studies, affiliate professor of political science, and associate director of the graduate program in philosophy at Baylor University in Waco, Texas. Commenting on Dr. Beckwith's paper is going to be Shaina Hewlett, who is associate general counsel at the Bruderhof, which is an international Christian community movement in the Anabaptist tradition. Our second paper presenter is the one coming into us beaming live from Starfleet on the screen, Dr. Alex Deegan, who is the senior lecturer in the School of Law, Queensland University of Technology. And commenting on Alex's paper, we have L. Martin Nussbaum, who is a partner at Nussbaum Spear Gleason, a Colorado Springs-based law firm serving religious institutions. So we're going to start by giving Dr. Beckwith 20 minutes to explain his paper.
Thank you very much. Thank you. Okay, that's better. Yes. It's a delight to be here. Like the other speakers in the other panel, I'm going to try to give you the highlights of my paper. I will resort to the text when I think that I've written it better than I could possibly say it on the fly. So the title of my paper is What's So Special About Religious Liberty? Law, Philosophy, and Serving God. According to a number of influential legal scholars, although religion has to be singled out for special, or had to be singled out for special protection at one time in our history, the reasons for that specialness no longer obtain. I call this the religion is not special thesis, or RNS. Defenders of versions of this view include everyone from Brian Leiter, Ronald Dworkin, Christopher Eisgruber, Lawrence Sager, Cecil Laborde, and Micah Schwartzman. One, for example, John Locke wrote his letter concerning toleration in the late 17th century. The divisions between citizens tracked almost exclusively along Christian denominational lines as a consequence of the Reformation's aftermath. But today we are told that the divisions track along different lines, ones that are more philosophical and ethical than those that are connected to theological distinctives. Thus, the RNS supporter reasons that we should interpret or reinterpret religious liberty to include not only conventional religions, but non-theological points of view that we are told provide the same sort of solace, meaning, and dignity as conventional religions do for their followers. In this paper, I want to suggest an alternative perspective, one that I call the two sovereigns thesis, or TST, a view that many of the American founders had in mind when they argued for incorporating its logic into state laws and constitutions. In presenting this alternative, I'm going to focus on those aspects of conventional religions that are often ignored or downplayed by RNS advocates. I will argue that the main reason for this neglect is that the RNS theory is an eliminative theory in its application, meaning that as an interpretive tool, it eliminates from our vision those aspects of religious belief and practice that have traditionally set it apart from other activities. By attempting to find one overarching theory of religious liberty that does not discriminate between deeply held religious and non-religious beliefs, the RNS advocate winds up offering, or so I will argue, an impoverished description of what religious citizens actually believe. Now, to arrive at this destination, I'm going to begin with an analysis of how religious speech is treated both as non-special and special in the U.S. Supreme Court's religion jurisprudence. Why choose speech rather than other activities? Well, philosophically, it is because speech is unique to the human species and the primary means by which we express our rational nature. Legally, it is because the primary conflicts over religion in the courts involve speech or expression, whether in the forms of words, symbols, texts, or ideas. This will lay the groundwork for the second part of my paper, in which I explain the two sovereigns thesis. I will then discuss how that thesis has better explanatory power than the RNS view in accounting for the nature of certain types of cases in religion jurisprudence. And given my time constraints, I'm going to probably only have time to give you one illustration of what I mean. There are others that I could offer. Now, let me just begin with going over a very brief summary of these two kinds of religion speech cases. So one kind of religion speech case is one that we're all familiar with, the viewpoint discrimination cases. So here I'm thinking of cases like Widmar versus Vincent, Lamb's Chapel, and Rosenberger versus the University of Virginia. In all those cases, there's a tendency in all of them for the court to look at religious speech as just another form of speech. Speech isn't special. There's nothing, or excuse me, religious speech isn't special. They tell us that the government, once the government sets up a public forum, it cannot exclude public benefits based on viewpoint, even a religious viewpoint, since religious speech is a species of speech. Religion in these cases is apparently not special. But that's not the same inference one draws in the other set of cases. In that collection of cases, which mostly always arise in the context of public education, the specialness of religion is precisely the reason why the speech is excluded. And so here I want to just go over some of the cases involving school prayer and school curricula. The case we're all familiar with, Engel versus Vital. The court considered a prayer that was composed by the New York State Board of Regents, and the Supreme Court, in the person of Justice Hugo Black, declares it unconstitutional. Well, why? Because the school should not be in the business of endorsing or supporting religious speech. It gives the government's endorsement or imprimatur. Maybe an imprimatur is not the right word. So what Black says, here I'm going to quote from the opinion. He says, the Establishment Clause's first and most immediate purpose rested on the belief that a union of government and religion tends to destroy government and to degrade religion, that religion is too personal, too sacred, too holy to permit its unhallowed perversion by a civil magistrate, unquote. But what precisely is it about the content of a prayer that makes it religious? Black gives us a simple answer. It's a solemn avowal of divine faith and supplication for the blessings of the Almighty, unquote. In a similar case decided the next year, in 1963, Abington School District versus Schempp, similar reasoning is used, and there, because it involves reading scripture, the court states that this is obviously a religious book, and the whole point of the exercise, in fact, the whole point of the disclaimers that the school districts have to put in place, that is, there's no interference allowed in terms of any student that wants to not participate, no comments are to be made by teachers, that reveals the religious nature of the activity. Religious speech continued to get the special treatment in the 1992 case, Lee versus Weissman. In there, the court writes, this is in the person of Justice Kennedy, the First Amendment's, quote, the First Amendment's religion clauses mean that religious beliefs and religious expression are too precious to be either proscribed or prescribed by the state. So what you find is that in these cases, or you find in the prayer cases, that prayer and reciting of religious text are not or at least those kinds of activities are ones that are distinctly religious, but those aren't the only kind of speech that the court singles out for exclusion. The other involves cases involving school curriculum, and here I'll just briefly mention the two cases, Epperson versus Arkansas and Edwards versus Aguilar. They're cases involving, in the Epperson, the banning of the teaching of evolution in Alabama public schools. There, the Supreme Court said that the fact that evolution was singled out because of its inconsistency with the book of Genesis shows that there was a religious motive, and the law was intending to protect a kind of religious belief. And in Edwards versus Aguilar, which was decided in 1987, the court dealt with the Louisiana statute that offered a kind of balanced treatment. They said if evolution were taught, creationism had to be taught, and vice versa. Obviously, you could teach neither one, and that would also fulfill the obligations of the statute. The court winds up rejecting that. Why? Because What's doing the work is the Genesis account of creation. And also the court looked at the historic and contemporary, this is a quote from the opinion, the historic and contemporaneous link between the teachings of certain religious denominations and the teaching of evolution. Now, in the second set of cases, those concerning prayer and curricula, religious speech is restricted because the government may not endorse a religious viewpoint, even if the viewpoint happens to be integral to the lives of many of its citizens. But as we saw in the first set of cases, the ones involving viewpoint discrimination, the government may not target religious speech for special burdens because religious speech is in fact not special. So it seems that there's something distinct in the second set of cases that warrants government prohibition that is absent from the first set. Now, one distinction is, and an obvious one, is that in the first set, the government merely provides the venue in which contrary points of views may be advanced by private parties, whereas in the second set, the government is the actor. But that doesn't quite answer the question as to what is it about religion that accounts for the differing treatment of religious speech between the two sets of cases. After all, the same public school teacher who is free to instruct her students on chemistry or literature cannot lead them in prayer or teach them creationism, even if approved by her government employee. So there must be something about religion that earns this exclusion. And here I want to talk about the two sovereigns thesis. So if one looks carefully at these cases, the second set of cases, what stands out are three things. One, sacred liturgy. Two, a transcendent source of being. And three, obedience to the divine. The first involves ceremonies, prayers, celebrations, symbols, wardrobes, postures, texts, and rituals that are often integral to religious traditions. Think, for example, not only of the prayers and scripture readings required discussed in cases like Engel and Abington School District, but also the restrictions the states placed on how these activities were to be conducted. I mentioned earlier the caveats that the state required that teachers not say anything or requires or mention any religious garb or anything of that sort. And if a student wanted to be exempt, they could not draw attention to that. You find this in some of the comments made by the justices. So Justice Black says, kind of draws our attention to this sacredness, right? He says, religion is too personal, too sacred, too holy to permit its unhallowed perversion by a civil magistrate. Kennedy, as you recall, says religious beliefs and religious expression are too precious to be either proscribed or prescribed by the state. Justice Harry Blackmun, in his dissent in Lynch v. Donnelly, refers to the creche as a sacred symbol. So you find in a lot of these Establishment Clause cases, this kind of referring to religion as having something distinct and set apart from other kinds of activities and speech. The second, a transcendent source of being, refers to God, the creator and sustainer of all that exists, the first cause of all contingent existence, who may have revealed himself through a sacred text throughout human history. We see this clearly in the creationist cases, though it is found in the prayer cases as well. In the creationist cases, the states of Arkansas and Louisiana lose precisely because the laws in question either imply or affirm that public school science curricula ought to be shaped by the belief that a transcendent source of being has specially revealed how he created the world. And the court argues that it's implying the presentation of it in the book of Genesis. The third, obedience to the divine, refers to what constitutes a right relationship with the transcendent source of being. This is the essence of the Regent's Prayer in Engel. It goes like this: Almighty God, we acknowledge our dependence upon thee, and we beg thy blessings upon us, our parents, our teachers, and our country, unquote. Now imagine if the New York Regents had merely required that students at the beginning of each day communally express gratitude for their parents, teachers, and country without any mention of God or our dependence on him. To be sure, some citizens would likely disagree with that and may appeal to the right of the student to be exempt from it, but based on freedom of speech, not freedom of religion. But unlike the Regent's Prayer, an exercise of gratitude, because it does not address obedience to the divine, would not violate the Establishment Clause, even if we later discovered that both the praying students and the gratitude cultivating students experience the same psychological degree of pride and thankfulness as a result of their exercises. What makes government-guided prayer and special and verboten is what is absent from government-guided cultivation of gratitude, obedience to God. So under these Establishment Clause cases, what makes religion special is that its adherents claim that there is a transcendent source of being to whom they owe obedience and who has specially revealed to them liturgical practices and other truths that are sacred and ought to be followed. Although separated from us by over 2 centuries and holding differing views on the propriety of religious establishment, leading voices in the early American founding recognized this reality about the religious lives of the nation's citizens. In my paper, I quote from several state constitutions as well as from James Madison's Memorial Remonstrance, so I will bypass that and just move to the way in which this understanding, I think, that at least Madison's understanding, and you find this in the state constitutions as well, is that there's something about religious beliefs and practices that are outside of the jurisdiction of the government. And I think you see this in some of the court's most recent cases, or at least over the past 100 years. The cases involving ministerial exemptions, church autonomy, and parental rights. In all these cases, you find this sense of a kind of almost epistemic modesty, that the state can go here and no further. Now, how does this, so it should be evident, at least this is what I argue in the paper, is that the two sovereigns view depends on a kind of again, epistemic modesty that arises from the nature of religious disagreement. As Madison said in his Memorial Remonstrance that I quoted earlier in the paper, but I didn't read to you, is that our religious duty to God can be directed, quote, only by reason and conviction, and thus should be left to each person's conviction and conscience. I think what stands out about that is the fact that for Madison, it's just not a matter of reason, it's a matter of conscience and conviction, in the sense that it's not always the end of the conclusion of a syllogism. It's also, in some cases, a belief that one may hold that one is not really in a position to reject. There's a sense in which our convictions, our religious convictions, choose us as much as we choose it. And I think he's trying to get that in his comments. So I've got how many minutes, like 3 or 4 minutes left, maybe? 4, okay. So let me just give you one example of how I think the religion is not special view comes up short in comparison to the two sovereigns view. And here I want to just bring up a case involving, it was a case called Equal Employment, EEOC versus Abercrombie and Fitch. It was a case involving a Muslim woman named Samantha Alouf, who applied for a job at Abercrombie and Fitch and was told that she had to wear a particular, or she could not wear the scarf that she was required to wear by her faith. And they then said, well, you to work here, you have to have the look of Abercrombie and Fitch, and you are refusing to do this, so we won't hire you. She wound up winning the lawsuit. She sued, and under the Civil Rights Act of 1964, as amended, there's a provision that says that employers must accommodate the religious beliefs and practices of their employees. And when you look at the way in which the religion is not special folks look at this case, I think they wind up sort of emptying it of the conviction that Ms. Alouf brings to the case. So let's look at the view held by Eisgruber and Sager. They have a book in which they defend this view called Equal Liberty. And they state, our theory depends on the idea that the state must not discriminate between religious conviction and comparably serious secular convictions. And they use as an illustration the example of a case involving 2 police officers in New Jersey who refused to shave because they were Muslim. And they wound up winning because the police department gave a health exemption. And so if you take that view of equal liberty and you would apply it to the case of Miss Aloof, you'd have to say, well, what gives her the right to do this, or at least to make this claim, is that the company would also relieve a employee of a health burden. But that is not why Miss Aloof holds the view that she does. She holds the view because she thinks that God told her and that she has to be obedient to God. And so there's a lot more that I could say, and I say a lot more in the paper, and I look forward to the comments. Thank you.
Thank you, Professor. Hold on. Thank you, Professor. Really appreciate you bringing us back to the founders' two sovereigns thesis. Because unlike the religion is not so special thesis, it recognizes that religious beliefs are not just strong opinions about important issues. Because religious believers experience their beliefs as divine commands and guidance from a sovereign to whom they owe obedience. So I agree with everything you said, and also the more you said in your paper about how believers can't be kept out of public conversations because they want to bring their faith with them, and how they shouldn't be forced out of their careers and jobs because they want to follow what God dictates to them, even at work. But I think in the spirit of this conference of going beyond defensive crouch, I think we can take a step even further than the two sovereigns thesis to describe the relationship between church and state. Clearly, church and state are not rulers of adjacent countries with defined boundaries. They're not even rulers over the same territory with equal but separate jurisdictions. As a believer in God myself, as a Christian, and also as a lawyer, I see these authorities in a very distinct hierarchy. I've been trying for a while to come up with an analogy because I think the image of two sovereigns really oversells government sometimes. The best picture I've been able to come up with is with God, or the divine, as a sovereign landlord owning and ruling over everything. Specifically, his multiple houses in which us, his tenants, live. For each house, the US, Australia, Mexico, he has appointed a property manager, giving her the task of keeping order, coordinating the shared use of common areas, providing security, collecting rent, and maintaining the building. In my analogy, as you've probably guessed, that property manager is the national government of a country. She has only limited delegated authority with regard to the landlord's tenants. As tenants, we should respect the property managers, and generally we should comply with their directives, but not if they step beyond their role or try to undermine the authority of the landlord himself. After all, our relationship to the property manager is because of and subordinate to our relationship to the landlord. At the risk of stretching this metaphor too far, I'd like to note that this model does not require that the tenants all agree who exactly the landlord God is. In fact, it's even possible for tenants to live side by side with atheists who don't believe the landlord exists at all, because the property manager's management should be sufficient to provide the basic order and maintain security so that you can still live in civil society together. So why does it matter that we see the government as a mere property manager, not as an equal sovereign? I want to answer that both as an Anabaptist Christian and as a lawyer. As an Anabaptist, and I think for most Christians, the obligation to God always comes before the obligation to obey state authorities, even at the risk of death. I don't see myself as having dueling loyalties, but I see myself as having full fealty to God, which then means that in most cases, I will obey government dictates. Then as a lawyer, I think viewing the national government as a property manager is a reminder that laws which interfere with the obligations of a believer to follow divine commands are actually beyond the government's authority. This means that the burden should be on the government to prove that laws restricting religious freedom are absolutely essential for maintaining order. Ideally, then, the state should interfere as little as possible with conduct directed by religious belief. It's important that we don't allow religion to be boxed into weekly services or specific ceremonies. Because for many of us, like for the Muslim employee or the Christian cake baker, who you also describe in your paper, our faith dictates much more than the prayers we say in the privacy of our homes. The Bruderhof community, of which I am a member, provides a particularly strong example because our whole lives are ordered in an attempt to reflect our understanding of God's teachings. For those of you who haven't ever run into the Bruderhof, I think the easiest way I can describe it is to say it's like a Catholic monastery or convent, but for families, and in the Anabaptist faith tradition. I can tell you more later if you're interested. So we live together in settlements of up to a couple of hundred, sharing our earnings, our work, our worship, and our faith together. Every aspect of our community life, from how we share all our income, to how we work together, to how we teach our children, and how we engage with individuals and groups beyond our communities, can be called religious. As a lawyer for the community, I'm keenly aware that unjustified government involvement risks disrupting a life that we believe is comprehensively structured around faith. It would be very difficult in our context to separate faith from life, because for us, faith really is everyday life. So that's why for us, it's particularly important that government doesn't overstep its appropriate authority. Thankfully, in this country especially, we still do have a very strong tradition of protecting religious freedom and church autonomy. And I believe communities like mine have a particular role in demonstrating why this matters, not least because our life together can be in itself a testimony to the state and to society in issues like family life, care of the vulnerable and elderly, child-centered education, the dignity of work, and accountable leadership. So I'd like to go further then and illustrate how strongly I think religious freedom should be protected. And the example I want to use has seemed for years pretty abstract, but the war in Ukraine has now brought it into focus again. Last month, Ukraine started conscripting its citizens to defend the country against Russian invasion. I don't know what the numbers are, but I know that at least some people in Ukraine have refused to take up arms because of their religious beliefs. I come from an Anabaptist tradition with a long history of conscientious objection, which at times meant that members were imprisoned or even killed because of their refusal to take up arms. So what should the government's response be if a citizen believes their faith requires them not to take up arms? It seems like this should be an easy decision for government. What can be more essential than defending the very existence of the country? But I believe that the state must recognize that religion is so special that it should exempt its people from military service, even when the nation's existence is at stake. Because a state that will insist its people must violate their conscience when there are other options available, such as non-military civilian service, other relief work, is a state that has stepped beyond its legitimate authority. So if I believe that religion is so important that states should permit conscientious objection in wartime, you probably won't be surprised to hear that I think religion is important enough that governments should also permit conscientious objection in peacetime. Specifically, health professionals should never be forced to participate in abortions or other procedures against conscience. Likewise, teachers and others who care for children should never be forced to teach them things against their beliefs or that they believe will harm the children. Nor should cake bakers and wedding planners be forced to participate in ceremonies in violation of their religious beliefs, as your paper details very well. When tenants believe the landlord has forbidden something, the property manager should be very cautious to claim that she can nevertheless compel that action. So I absolutely agree with you that religion is so special that we need to make sure government understands and respects this. Thank you.
All right, I think next up is Alex online.
Thank you very much. And I hope you can all hear me clearly. I can only see the panel members, so just give me a thumbs up if I'm clear. Great. Okay, well, I'd like to first of all thank the Scalia Law School and the Law and Liberty Center and Helen in particular for putting together this conference and for facilitating my virtual participation. I am sorry I couldn't be there in person, but I know everyone's excuse for everything is COVID, but unfortunately COVID did make things more difficult. And it is a bit disconcerting staring at yourself on a giant screen for 20 minutes. And I discovered tics I didn't know I had. So I also apologize for subjecting everyone to that. I do have some slides that I'm going to share to facilitate my presentation. Unlike the previous panelists who very graciously said that they wouldn't try to summarize their entire paper in 20 minutes, but would rather just kind of provide highlights, I'm going to be foolhardy and attempt to summarize my entire paper in 20 minutes. And I'll leave you to judge how successful I am in that task. So I'm just going to share my slides now. Okay, so I hope you can all see that. So I've entitled my paper, Creating Peaceful Coexistence Through Virtue, a Theological Approach to Institutional Religious Freedom, Equality, and the First Amendment. So as we're all aware, the conflict or supposed conflict between religious liberty and equality has occupied much of the religious freedom literature lately, and scholars on both sides of the debate, so far as they are diametrically opposed sides, have called for empathy and compromise and generosity, particularly recently. But what I think is that in the absence of a really robust and principled framework for such reconciliation, these calls are nice, but they're really just empty platitudes that don't provide any tools for change. And so what I aim to do in this paper is to give substantive content to those calls by proposing a theological framework which establishes a peaceful coexistence of difference through the cultivation and application of the Christian virtues. And over the course of this paper and of this presentation, I'll unpack a bit of what that means and then briefly explain how that might apply to some of the contentious issues in this space. So what I mean by peaceful coexistence is the ability for difference and diversity to coexist peacefully. So Christian theologian John Milbank calls this the reconciliation of virtue with difference, which orients people to the good. So people can pursue virtue and pursue the good in diverse ways, but in a way which is also harmonious. And what I mean by the Christian virtues are those virtues which are articulated in scripture. So things like the affirmation of human dignity through being created in the image of God, the law of love and compassion, patience, forgiveness, humility, kindness, and so forth. And I think in this space, dignity and forgiveness are particularly relevant because dignity, as I've said, recognizes the inherent worth of all persons as created in the image of God. And forgiveness requires a recognition and a willingness to accept that there is profound moral disagreement and to not try to squash disagreement, because we can still love our neighbor as ourselves by aiming to persuade people to that which we believe is true and good. Adopting these virtues produces a posture which refuses to accept the inevitability of conflict and rather strives for a harmonious coexistence of difference. And in particular, peaceful coexistence can be derived from the law of love, to love your neighbor as yourself, which is exemplified in the parable of the Good Samaritan and by Christ himself, the idea of selfless sacrifice for the good of the other, even at personal cost. And as a mode of political interaction, it goes beyond the straightforward and traditional classical liberal approach of live and let live or agree to disagree, the laissez-faire liberalism. Rather, it positively and actively seeks the good of self and other, realizing that we all live in an interdependent community. And Christian theology is uniquely suited for articulating this framework for difference, because Christianity accounts for difference, both in its praxis as the church, the body of Christ, where each part has a different function, yet all parts are equally necessary and operate together in harmony. And Christianity also uniquely accounts for difference in its ontology, and namely in the Trinity, the triunity, three distinct persons with one divine nature all coexisting harmoniously together, or perfect unity in diversity. And so this ideal can be sought through the practice of the Christian virtues, which are simultaneously shared virtues. So you don't have to be Christian or have Christian belief to practice the virtues of humility and patience and kindness and forgiveness. These are virtues which are universally desirable and can be universally practiced by all, regardless of belief. Now, there may obviously be some concerns about using an explicitly theological framework like this as kind of an evaluative criteria for critiquing the legal framework of what you might call a religiously diverse, secular, liberal democracy like the United States, or indeed like Australia or the UK or many European nations. And so the fundamental question to address to take that concern into account is whether the Christian framework can account for religious diversity. But before I do that, I do think it's worth noting that the so-called secular or non-religious framework for addressing religious diversity actually does quite a poor job at that. Because a secular framework, by its nature, marginalizes and minimizes religion by using inadequate secular analogies, as other panelists and commentators have indicated. And as I mentioned before, the Christian framework relies on shared premises. So everyone, regardless of belief, can understand and practice these virtues. This Christian framework has appeal to non-Christian religious communities because it's an approach which is friendly to and acknowledges religion. It understands religion. But it also has appeal to non-religious communities because it's a more deeply coherent framework for recognizing intrinsic dignity. And the secular approach, I believe anyway, does not have the tools to do that. Even the so-called liberal virtues that are secular in their articulation, like freedom or equality or tolerance, I've argued in other work that these actually find their culmination and true meaning by understanding them in their Christian context. And finally, religious community is beneficial to society more broadly. As I think Elizabeth Clark's paper earlier very ably pointed out, for religious communities, there's an exercise of solidarity which mediates between the excesses of privileging the state or privileging the citizen, the individual citizen. There's an assumption of responsibility for both individual and community operating together in harmony. And by providing an explicitly theological approach, It also provides a transcendent significance to persons. It points out the eternal foundations of citizenship and of political relationships, thereby enhancing democracy by encouraging mutual interdependence and motivating people to act virtuously towards each other. So what does this mean for religious freedom and equality? Well, in this paper, I am just going to very briefly focus on the First Amendment and look at the Establishment and Free Exercise Clause. And we've already heard a lot about the Establishment Clause, particularly of Professor Bradley's paper, so I'll just very quickly go through this. I also agree that Establishment Clause jurisprudence is problematic due to the Lemon test and its unclear and inconsistent application, and also its kind of continued adoption of the hackneyed and I think incorrect wall of separation metaphor. But a better way to interpret or to apply the Establishment Clause is to enhance and encourage pluralism, which facilitates religious liberty and actually protects religion, because rather than separating religion and government, it enables the beneficial interaction of religion and government for the broader benefit of the community. And so by adopting an interpretation which simply prevents government coercion or discriminatory preference, the clause can facilitate a vibrant and pluralistic religious presence in society. And as Elizabeth Clark has pointed out, religion can increase human flourishing, and adopting this approach will hopefully decrease unnecessary cultural battles which are aimed at excluding religion by exhibiting the Christian virtues and a willingness to foster genuine diversity. In terms of the Free Exercise Clause, I argue that the decision in Employment Division and Smith significantly curtails religious freedom by saying that if religion is not specifically or explicitly targeted, there are no restrictions on how government can, in effect, inhibit religion. This decision is problematic because it's a narrow and secular approach which does not love our religious neighbours by recognising that many activities external to private practice of religion, such as the provision of education and welfare, are equally as religious for many people. And burdens imposed on these activities by generally applicable laws can remain substantial burdens. However, the Supreme Court has, I think, rightly been moving away from the decision in Smith, and in fact, the last 11 cases, by my count, over the past decade relating to religious freedom have been wins for religion. And in particular, the cases of Espinoza and Fulton have demonstrated an embrace of patience and forgiveness, upholding the dignity of religious organizations by ensuring they're not discriminated against by government in the way they receive funds, in the case of Espinoza, or in the way they provide services in accordance with their religious doctrine, in the case of Fulton. One proposed method of reconciling freedom and equality in this space is through, as we've talked about, the idea of religious exemptions, which of course then create tension with anti-discrimination laws, as exemplified in cases with similar factual scenarios to Masterpiece Cake Shop. And so there's a difficulty to work out here. Obviously allowing blanket discrimination against members of the LGBT community seeking goods and services, I think, damages peaceful coexistence by undermining the virtues of dignity and kindness. But on the other hand, not providing any exemptions at all also undermines the dignity of religious vendors by imposing burdens of conscience upon them. And it also rejects the virtue of patience by presenting a very difficult ultimatum to those religious vendors. Either they must violate their conscience and provide the goods or services, or they suffer the penalty of the law, or they must completely change their profession. And I think peaceful coexistence just isn't possible under those kinds of conditions. And so what I argue in the paper is providing religious vendors with narrow and clear exemptions contributes to peaceful coexistence by upholding the dignity of all parties involved and encouraging patience and forgiveness in the face of profound moral difference that exists. And finally, in terms of the ministerial exception, I think the ministerial exception is a religion-friendly approach to religious communities by providing a sphere of autonomy to protect decisions by institutions relating to the employment of ministers, to the development and application of doctrine, and to management of their institutions. And so in this sense, the ministerial exception therefore contributes to peaceful coexistence by upholding the dignity of religious organizations to conduct themselves in accordance with their own beliefs. And it encourages love of neighbor by enabling religious institutions to develop diverse and rich visions of the good, and also recognizing that those institutions deploy those visions of the good for the broader benefit of the community. But I also think the potential scope for unconstrained discrimination means improvement is possible. Under the ministerial exception, it's possible for religious employers to discriminate without any religious reason. It could be for any reason at all, and the court just doesn't touch it. And so what I propose is that the ministerial exception could be slightly narrowed by only protecting employment discrimination, which is religious or based on religion-related reasons. And in the paper, I take a broad view of what that means and explain the implications. And I think this would still provide a broad scope for protection while also acknowledging equality concerns. And I'll finish off there. Thank you very much.
Okay,
I tried turning
great.
off the mics because I thought there might be some echo happening.
Thank you very
Please go
much.
ahead.
And it's just a delight to be here and away from all the deadlines that fill my day hour by hour, because as you heard from the introduction, I represent religious institutions, and much of that involves litigation. So thanks for having me, and thanks for inviting me. I want to offer for Professor Deegan 4 cheers for his paper and 3 comments that I hope will be constructive. The first cheer. Professor Deegan contends that the application of these theological virtues will lead to, and I quote, a recognition of the inherent worth of all humans in the image of God, a willingness to permit genuine difference while accepting freedom to reject and disagree with our most deeply held convictions. That is a worthy goal. But I want to focus in particular on this phrase, that we are in the image of God, that our inherent worth or human dignity comes from being in the image of God. What does that mean? It refers, I think, to the greatest miracle of all, that each of us across time and culture have a conscience, a substantially similar sense of right and wrong. It's a miracle because you cannot begin to explain the implantation of that conscience by biochemistry or biology or any way. If we have a conscience, how do we become conscientious? We do as Aristotle taught in the Nicomachean Ethics long ago, is we practice virtue. We exercise those virtues, and this requires freedom. As Shana said, the obligation to God is prior to that of the state. It's because we are in the image of God, we have a conscience, we must practice virtue. Second cheer. Professor Deegan has a broad definition of religious communities in his paper as extending to vendors and businesses as well. That's laudable. There are many, many associations of business leaders, both Protestant and Catholic, that I'm aware of, that take quite seriously how do they carry their religious witness into the working with employees, into their acquisition activities, into the marketplace. Third chair, Professor Dagan, like I guess most everyone here, has offered a critique of the lemon test that serves the purpose of the Establishment Clause, and he cites Professor Stephanie Bradley, who offers an alternative that says, and I quote, that religious groups, that the Establishment Clause should protect religious groups from government interference in their internal affairs when it prevents the government from preferencing, and it should prevent the government from preferencing particular religions. I would also suggest that in addition to citing Professor Bradley, that you cite to, that Professor Barkley, that you cite to Professor Bradley, because he clearly has written a magnificent work on this. Fourth chair, Professor Deegan offers a devastating critique of what I see often in religious liberty disputes, where the opponent that I'm opposed to is seeking to cabin religion, and part of the way they do that is arguing the so-called third-party harm thesis. And I was reminded, Shana, when you made your remarks, what Professor Deegan says in his paper, that one of the first conscientious objections and most widely respected conscientious objection is those who conscientiously object to war. And of course, that causes a third-party harm. And from the earliest days, the respect for those who are conscientiously opposed to war has been part of our tradition. In fact, I have on my wall a letter that George Washington wrote to the Pennsylvania Council of Safety, where he calls for the imposition of a draft when the war wasn't going well. And he says, we need now more men than money, but of course not those who are conscientiously scrupulous. So at the time that our very nation's existence was at stake, he's putting his thumb on the scale for freedom. Now, a few constructive comments. First, given Professor Dagan's substantial discussion of virtue, I found myself asking a question. Virtue for whom? It's a little bit unclear in the paper who that call is for. And when I was reminded of John Plamenatz's thesis from his History on Liberty of Conscience in his important book, Man and Society, 1963, offering the example of the Congregational Puritans, who, while a minority in Europe, called for toleration, and who surrendered any idea, quote, that the state should support the one true church against others. Those Congregational Puritans changed their tune in Massachusetts when they, quote, found themselves in the majority and became as eager as Calvin had been to use civil power to make their church supreme, end of quote. When the culturally dominant Puritans expelled Roger Williams and Anne Hutchinson from Massachusetts, were Williams and Hutchinson, or the Puritans, most in need of hearing Professor Dagan's call for virtue? This leads to the question, where lies political and cultural power today? It is, I contend, with the LGBT activists. Consider Plamenatz's thesis in light of the progression of demands from those activists. First, there was a call for decriminalization. This happened in Lawrence v. Texas in 2003. Next, there was a call for freedom from discrimination protected by statute. And we saw that the EOC by 2017 or so had begun interpreting Title VII as including the prohibition on sex discriminations, including LGBT, were included with that. Even earlier, by 2012, 30 states had defined sex in their state anti-discrimination statutes as including sexual orientation. Next was a call for constitutional protection, and we saw that additional protection in the Windsor case in 2013, voiding the Defense of Marriage Act, and the Obergefell decision in 2015, recognizing a constitutional right to marriage. So far, so good. Next came, though, a call for entitlement because of such status. Even if the political minority, in terms of power, I would say, including the religious community, must pay for what it considers immoral. For me, the primary example of that is the 2016 regulation issued by HHS interpreting the Affordable Care Act, which said that all employers must cover in their health plan gender transition services, even if they're morally opposed, and there was no religious exemption offered in that regulation. Next month, I believe, HHS will be issuing an even more aggressive regulation because it has so promised 3 times in a court proceeding involving the Whitman-Walker case. In that case, they attached a 74-page memorandum from the Leadership Conference, and they have said repeatedly with regard to that memorandum of A, we're going to issue a regulation next month in April of 2022, and B, Whitman-Walker will not be disappointed with our regulation. That 74-page memorandum came from 30 sexual rights activist groups that call themselves the Leadership Conference. What do they call for? They call for HHS, interpreting the Affordable Care Act, to issue a mandate that all employers cover in their health plans gender-conforming surgeries, gender-conforming cosmetic surgery as well as gender transition surgeries, surgical abortion, reproductive health care, which I suspect may possibly include chemical abortion, and contraceptive abortifacient, sterilization, and counseling. This mandate will be similar and beyond the 2016 mandate we previously saw, and it will include not only a mandate that employers must cover this and pay for it in their health plans, but if you are a physician or a medical provider and you're competent to perform such procedures, you must do so with your own hands. No religious exemption. Next and beyond that is a speech mandate. The 2016 regulation already forbade that medical professionals could not critique the medical efficacy of gender transition services. We have seen this speech mandate in other settings. I am presently defending a large Catholic health network, the Catholic Health Initiatives, in a case where they terminated a physician for beginning to preparing a patient for physician-assisted suicide, contrary to that physician's contract, which incorporated the ethical and religious directives of the Catholic Church by reference. In that case, we presented 4 different constitutional arguments as why to dismiss the case, and we referred to the procedure as physician-assisted suicide. The court has now imposed a gag order on me and my partner that we may not use that phrase physician-assisted suicide, even though we're making a moral objection based upon constitutional principle. Another example of a restriction on speech, I believe, are the anti-conversion therapy laws, which create a one-way ratchet in the 20 states in the District of Columbia that have adopted these. If an individual wants to transition from their biological sex to the sex that they identified, they are permitted to do that, and mental health professionals are permitted to help them. But if they find that destination to be unsatisfactory or unhealthy for them, and they want to transition back, no counselor can assist them in moving back to their biological state. And to complete full circle, the remedies or the sanctions for violating the 2016 regulation, and I predict the April 2022 regulation, include criminal imprisonment or criminal conviction and imprisonment for Catholic healthcare professionals and other Christian hospitals and physicians who would be morally opposed to some of these procedures. So we've gone full circle from criminalizing certain sexual acts to criminalizing those who with their own hands won't assist that. Given this reality, which group is most in need of hearing the call to virtue, the call to restraint? My second observation. Professor Deegan's definition of religious autonomy, while admirably broad because it includes individuals and vendors, its very breadth, I believe, complicates consideration of the most important protection for the freedom of religious institutions, and that is a protection known as the doctrine of church autonomy. This is a First Amendment doctrine most easily applied for the protection of religious societies, but seldom applied for businesses owned by religious individuals. Because of the breadth of the definition, it is natural that Professor Deegan focuses on the classic applications of free exercise clause and the establishment clause, and only considers a subset of the doctrine of church autonomy called the ministerial exception. While these protections are important, I think the paper neglects the doctrine of church autonomy. And I would note, when we go and advocate in a court, I always say to myself and my colleagues, you need to understand that this is probably the first religious freedom case your judge has heard. And when he took con law he and she took con law 20 years ago and had 1 hour devoted to religious freedom, they never even read Watson v. Jones, which has been cited by 1,000 precedents, published precedents, articulating the scope of the doctrine of church autonomy. Well, what is this doctrine? Founded in an 1871 decision, Watson v. Jones developed through a series of secessionist congregation and intra-ecclesiastical leadership and property disputes, recognized a broad articulation of the freedom of religious associations for independence and freedom from control by secular manipulation. Things to note about the doctrine of church autonomy are the following. While it embodies both the free exercise clause and the establishment clause, as confirmed in footnote 4 of the Hosanna-Tabor case, it does not decide those cases by applying strict scrutiny. It doesn't decide those cases by applying Smith's rational basis analysis, and it certainly doesn't decide them by deciding the tripartite Lemon test. Rather, when a dispute touches upon or interferes with ecclesiastical subject matters, the government court should resolve the dispute by deferring to the hierarchical body within the religious society. What then are the core ecclesiastical subject matters? They include the church-minister relationship, which is important, but include also doctrine, ecclesiastical law, preaching and teaching, and ecclesiastical speech and other religious communications, church-parishioner relationships, charitable trusts, ecclesiastical tribunals, and more. And the Smith case specifically reaffirms the undiminished vitality of the church autonomy jurisprudence. Finally, a couple of suggestions regarding Professor Deegan's offers of applying virtue, attempts to limit the scope of these religious freedoms. The first is he offers an excellent critique of the third-party exception, but then he says that there may be a compelling interest to deny the exemption if it would materially limit access to goods or services. And I wonder, why should the scope of one's religious freedom depend upon whether he has competitors nearby? Should there be more religious freedom in a city with a lot of vendors than in a small town? This position could have devastating effect on Catholic hospitals in rural settings. In fact, the Leadership Conference memo makes that very argument, that Catholic hospitals deserve no religious freedom if they're the only game in town. Next, he proposes 3 limitations on religious autonomy. First, it says that with regard to limiting autonomy's vertical dimension through criminal sanction when the religious institution authorizes violence and carries it out. I think it's hard to articulate the limits of the church autonomy, but I think that's successful, that if it authorized violence and carries it out. But I would caution that criminal law is not the proper limitation on religious autonomy. Consider, for example, those calling to criminalize the Jewish practice of circumcision. If that became a crime in the United States, would religious autonomy not carve an exemption from that crime? And we have seen numerous cases where courts have applied religious freedom principles, even when a crime was involved. Next, he argues that limiting autonomy's horizontal dimension may be appropriate when it unjustifiably infringes upon the fundamental rights and freedoms of others. Well, my state, Colorado, and others right now are considering passing laws that would define abortion as a fundamental right. And if so, if you applied a fundamental right exception to this freedom, now you've created another exception. As part of that portion of his text, he says that limiting religious autonomy might be appropriate if it burdens the freedom of others, when it involves a fundamental right or the freedom of others. And that seems to me like simply a restatement of the third-party harm. And finally, I would say in closing, that he suggests that the limiting of the ministerial exception might be appropriate when the religious employer's discrimination is completely unrelated to religion. Well, it can't be completely unrelated to religion because the church-minister relationship, courts have said again and again, is inextricably and intrinsically religious. And I would offer the example of a case I had the privilege to argue before the Massachusetts Supreme Judicial Court called Williams versus the Episcopal Diocese of Massachusetts, decided in 2002. This involved a woman Episcopal priest who alleged unequal pay, discriminatory treatment, and retaliation. And she argued, I argued the ministerial exception, and she argued the third-party exception. The Massachusetts Supreme Judicial Court said, and I quote, "A trial on this matter would clearly involve assessment of the church's priorities of its ministries and require defendants to defend the church's policies regarding ministers. It is true that plaintiffs' claims do not, on their face, question the verity of religious doctrines or beliefs. But it's hard to conceive, however, how a court could inquire into the reasons of the Episcopal bishop's decisions regarding the plaintiff's ministries without intruding into matters of internal management of the diocese." Thank you very much.
All right, thank you to all of our panelists. We have a lot of really worthwhile ideas on the table, and I want to start by asking whether any of the panelists have any thoughts, responsive thoughts to things that they've heard from other people. Why don't we just go down the road? We'll start at the other end and start with Dr. Beckwith. What's your?
Yeah, so I want to turn my mic on. Something that Mr. Nussbaum brought up that I thought he was talking about how the law has changed over the past 20 or 30 years in terms of the decriminalization of homosexual activity, and then, to the where we are today, where we have the federal government involved with requiring hospitals and physicians and healthcare plans to do things in violation of the entity or individual's conscience. I've seen this in the philosophical literature, this shift from a kind of political liberalism. That is, what I mean by political liberalism is it's a kind of a term of art coined by John Rawls. And it's that in a free society, people are bound to disagree on a variety of very important questions. And it's because generally most people that disagree are often equally informed, equally intelligent, and have reasoned through a lot of these questions. And the arguments in terms of the sort of liberalization that we saw, let's say through the 60s or the 80s, was based on this kind of Rawlsian argument. That is that free societies by their very nature are going to result in people coming to different conclusions about these fundamental issues. At some point, political liberalism kind of morphed into what I call hegemonic liberalism. That it's no longer do reasonable people disagree. It's that there's just simply one side and get in line. And I think that is a subtle, it's subtly happened. And I'm not sure, I've written about this in different works, and I'm not sure, maybe the whole politically liberal vision was not possible, right? I don't know. But I tend to, be attracted to that way of thinking, and to see how things have shifted is quite very disturbing.
Yes, I was actually thinking along very similar lines. I really appreciate your presentation, Professor Dean, on how focus on the virtues and return to the virtues can bring society together, but it seems that is very hard to do in the current context, where it's no longer acceptable to say, I love you, but I hate what you're doing, which is certainly my position on a lot of things, because that disagreement with what someone is doing or how they are expressing their identity, we're no longer allowed to separate that from who they are and from whether we respect their dignity as an individual. So I'm not sure how we resolve that, especially in an age of social media where you don't get into nuance. You don't get to build a relationship. Really appreciate what you said, Shannon, about your teacher who reached out to you, and though he had conservative Christian beliefs, you could tell he loved you. You can't do that on Twitter. So I'm not sure how we achieve that now.
Alex?
Thank you, everyone. Just to go immediately respond to Shana's comment, I think Twitter is probably not the best mechanism to ventilate those kinds of concerns. And I think kind of more substantive engagement, both scholarly and also just personal engagement, is probably a better way to go to utilize those virtues to build common ground. And that's starting to happen in the scholarship, or at least that's my reading of it. But I still think there's no kind of principled framework for doing that. And that's what I'm aiming to provide. In terms of Mr. Nussbaum's comments, I'll just make a couple of brief responses. In terms of virtue for whom, I think virtue for everyone. I think just as there are what you might call LGBT extremists who are pursuing kind of total crushing victory and don't care about religious persons or their consciences, there are also some extremist religious people who are prejudiced and just hate gays and lesbians. And then, of course, there's probably the majority of people which fall somewhere in the middle of those two extremes. And so I think we all need to cultivate those virtues. In terms of the problem of readily accessible alternatives and whether this justifies limiting religious autonomy for those vendors who may be, as you said, the only game in town. Yeah, I had difficulty resolving that tension because in an ideal world, I don't think anyone should be asked to violate their conscience. But I also recognize realities, and it's the problem of pushing for the ideal view means that we're going to continue this kind of irreconcilable tension, which may or may not end up in a particular party's favor. And so what I'm kind of angling towards is more of a compromise, not a compromise on religion, on religious doctrine, but on how religious freedom functions in society. And then in terms of the ministerial exception, where I talked about religion and religion-related reasons, I take a very broad view of that. So, for example, taking that approach wouldn't change, in my reading of the decisions, it wouldn't change the decisions in, for example, Hosanna Tabor or Our Lady. I think those were, even though they were under the pretext of ostensibly non-religious issues such as disability or such as professional development, I think underlying those were ultimately religious reasons that were perhaps just not very clearly articulated. And in situations where religious organizations have a reason for dismissing someone, I think they should be entitled to provide evidence that what their reason was religious. And I don't think there's any conceptual or doctrinal problem with them doing that. So I do take a very broad view of that religious reasons limitation. So it's only a very slight limitation. I do have a question for Professor Beckwith as well, but in the interest of time, I might contact him later and allow other audience members to pose questions.
Okay, would you like to say anything?
I would just want to emphasize, I totally agree that we should all be called to virtue in every aspect of our life, at every minute of our life. That is a wonderful part of your reflection, which I did not anticipate we'd be talking about this at a law school, at much less an august law school like this. One of the things that when I have young lawyers is something one of my mentors said to me is, get out of your desk when the case begins and go see the other side. And if you're in a city and it's local litigation, go to their office, sit down with them, and begin discussing the case. It really Face-to-face human encounters are just, they inculcate virtue right there in just what courtesy requires in that moment. And I would pick up on something Anthony alluded to very briefly that we haven't talked about when we talk about the freedom of religious institutions. One additional way to understand this doctrine of church autonomy is what Carl Esbeck has taught in his papers, that it functions as a structural restraint on the government. And another way to think about it is just as we allocate certain powers to the state and to the feds and to the different branches of the federal government, we say, look, religion, you are free with regard to doing that. That's an important limitation on governmental power. And if you look at the annual reports of the United States Council on International Religious Freedom, those countries that have religious freedom have all sorts of other rights, and they are far more economically prosperous, and they're much more tolerant of every type of minority, including sexual minorities, which has been mentioned here as well. So I think that's a helpful thing that Carl has done in talking about it as a structural restraint on government power. And I hope every one of you who teaches religious liberty are having your students read Watson v. Jones and Kedroff versus St. Nicholas Cathedral. You do that, Helen? Okay, good. Okay. Doug Laycock did not have us read it when I studied under Doug.
Yeah, so we have about 5 minutes. Does anyone have a relatively briefly statable question to address to anyone? Yeah, I guess you should come to the mic.
I have a question from Ms. Hulit. So we agree that a Christian-owned business shouldn't be forced to hire somebody who goes against their convictions. We also agree that government shouldn't put special burdens on religions. But I think the one thing I would push back against, and that I would like to get your response on, is that isn't it arguable that in order to protect religious rights truly, that first and foremost we have to protect the right to association, the right to order your affairs the way you want to. And in some cases, that may mean a business may not hire somebody because of their religious conviction, but I think ultimately it comes with the awareness when government orders civil society, it opens the door for the kind of discrimination that we see today, even against religious people. It was to Ms. Hulit, but I'd love to hear from anybody who's interested.
Sure. Yes, I think the freedom of association is often ignored, especially in the context of civil society organizations that are not necessarily religious, because we have the church autonomy doctrine, we have ministerial exemption. But I do think it is tricky when you get into business issues, because if you're making carpets, do you really have to care that the person making carpets next to you is also Muslim when you're Muslim, Catholic when you're Catholic? So I do think you have to have a connection between what you're trying to do and a requirement for people to be of the same belief. It gets complicated when you're in an organization like mine that does a lot of things and we think everything works together for the religious purpose we have. But I think you still need to think in every case, is there a good reason that this person does need to share the religion? And often there is, but I think we can't just say, if you want to discriminate against someone because of their religion, go ahead.
I would hesitate.
Yeah.
I would hesitate with the. Oh, that's good. Oh, okay. I would hesitate to try in some way to account for religious liberty by putting it under freedom of association. I'm not suggesting you're doing that, but there are scholars that do that. And in fact, Eisgruber and Sager in their book, they say, well, we can handle a lot of these autonomy issues by just having freedom of association. I think it diminishes why people are drawn together in a religious body. They're drawn together because sometimes they think they're chosen, right? Or they think that they are, called by God in some way. And so I hesitate to sort of try that, try to find that one principle that can account for religion and non-religion. Again, I'm not suggesting you're saying that, but that would be my hesitance to try to apply it, as some way to deal with these conflicts in religion.
I would point out that Watson v. Jones was decided exclusively on association laws, right of association, and it was later recognized as articulating First Amendment constitutional principles. In my shop, we know that sometimes religious freedom is in such popular disrepute that other rights can get us home in protecting that religious society. So we do argue speech, we do argue association. I even argued substantive due process one time. Yeah. Yeah.
Thank you very much for being here.
Thank you.
All right, I think that is the end of our time, so please join me in thanking our panelists.
Hazel Hall in the atrium. So please join us in Hazel Hall for the atrium. There will be some people directing you in that direction. Thank you.